Gov and Law 2.2. This is Unit 2, Rights as included in the Bill of Rights of the United States Constitution. These are the rights of the accused, the 4th, 5th, 6th, and 8th Amendments to the U.S. Constitution. We'll start with the 4th Amendment. The 4th Amendment includes several parts. It is the right of the people to be secure in their persons, houses, papers, and effects against reasonable searches and seizures. So searches and seizures is one part of the 4th Amendment. The next part of the 4th Amendment says that no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person and things to be searched. So that maintains that in order for a search to be legal, it must have probable cause. In addition, it must be certified by a judge or other official describing the particular place to be searched and the person and the things that they are actually looking for. The 4th Amendment was included by our founding fathers to maintain the rights of the accused against unreasonable searches and seizures by officials, whether those be military or police. The 4th Amendment is one of the most controversial amendments in the Bill of Rights, the first 10 amendments to the United States Constitution. It has a lot of gray area, and over the past 200 years, there's been several court cases which have strengthened or clarified the language of the 4th Amendment. Police need probable cause to search you or your property. But what is probable cause? That has been determined through several court cases over time. Search warrants. If there is a legal search warrant allotted, what if they find other items? For instance, what happens if in a legal search they are looking for illegal drugs and they find those illegal drugs, but in addition to that, they find stolen items in the same premises. Additionally, there has been a question about what's called the exclusionary rule. The exclusionary rule is used by courts to remedy the violation of the right against illegal searches and seizures. For example, in Mapp v. Ohio, which was a Supreme Court case in 1960, an illegal search of a home for a fugitive turned up evidence against Mapp for obscenity. The Supreme Court argued that the evidence was inadmissible in court because the search was illegally conducted. Therefore, the exclusionary rule was put into place. When a right, such as illegal searches and seizures, is violated, there must be a remedy or a fix. That fix is the exclusionary rule as determined by the Supreme Court, that any evidence that was illegally obtained cannot be admissible in court. Additionally, there's this question about what's called exigent circumstances. So for example, if the police believe that there's something in a vehicle that could be used as a danger to the public, for example, several guns, weapons, bombs, etc., obtaining a search warrant can sometimes be lengthy and problematic as far as time goes, contacting the judge, getting the evidence entered, etc. So typically, exigent circumstances, those where the car could easily be moved and those circumstances could change quickly, are not covered under the 4th Amendment, which gives the police more leeway to conduct searches in exigent situations where the evidence can be moved quickly, such as in a car, and changed and covered up. Many of you likely have questions about how the 4th Amendment applies to schools. School authorities can search your property on school grounds. Cases involving schools and the 4th Amendment, those searches and seizures, have long been part of Supreme Court history. Schools generally have been less restricted than police. They've been granted what the courts call a parental guideline, as the goal of schools is to provide safety and educational and character development for both you and the school community. Therefore, privacy is generally not covered in the 4th Amendment, as privacy is not even part of the 4th Amendment in its actual language. With that being said, as schools are typically given the rights of parents, therefore they have fewer restrictions than law enforcement, although they don't have the criminal enforcement part that the police do. There's been a few landmark Supreme Court cases which have strengthened the rights of schools against 4th Amendment violations. One of the first landmark cases is what's called New Jersey versus TLO in 1985. New Jersey is the state of New Jersey versus TLO, that's the initials of the 15-year-old student involved in this case. The 15-year-old student, TLO, are her initials again, was found smoking in the school bathroom. Upon searching her and her belongings, the school officials found cigarettes, rolling papers, marijuana, a pipe, plastic bags, a large amount of cash for a 15-year-old student, as well as a list of people who owed the student money. That case made it all the way to the Supreme Court, and the Supreme Court determined that that search of the student belongings were legal even though the school did not have a search warrant because the school had probable cause based on the fact that she was caught smoking to search her belongings. And they further had case to do that because their goal as a school is to provide safety and educational opportunities for other students, and therefore having drugs in the school with the possibility of her dealing those drugs was not a violation of her rights. Another landmark Supreme Court case in reference to the Fourth Amendment in schools is the School District of Vernonia versus Acton in 1995. This is an Oregon school district that had a serious drug problem over the course of the late 1980s, and so they began testing their students involved in any extracurricular activity. A seventh grader who was wanting to participate in extracurricular activities refused the drug test on the grounds that it violated his Fourth Amendment rights of unreasonable searches and seizures. However, the Supreme Court determined that the rights of the student were balanced with the responsibility of safety that the school had to both the school community, other students, parents, and the community at large. Therefore, drug testing students for extracurricular activities in public schools is legal and does not violate the Fourth Amendment. Please note that these cases only involve public school environments. Private school environments are much more restrictive as there is a contract for tuition and a contract for eligibility to participate in that school. Additional rights of the accused as covered by the Bill of Rights, the first 10 amendments to the Constitution, include the Fifth Amendment. The Fifth Amendment includes several portions, which we'll talk about each of those portions separately. The Fifth Amendment covers grand juries for capital crimes. A grand jury is typically one that determines whether or not there is enough evidence to take the court case to actual trial. Capital crimes are those crimes involving murders and other very serious felonies or federal crimes. The Fifth Amendment also protects your right against double jeopardy. Double jeopardy is your right to be accused of and stand trial for the same incident more than once. It also includes the right of due process. Due process is the steps that are taken when you are arrested and brought to trial. There are several steps that occur in that process, and every person must be afforded the right to that same process in the same order. It also protects your right against self-incrimination. You do not have to say anything which would incriminate you in any kind of case that you are accused of. It also covers this thing called eminent domain, which is the legal taking of property from a private property owner by the government. The Fifth Amendment that most people are most familiar with, the portion of it anyway, is the Miranda warning. The Miranda warning is typically what you hear on TV shows when a person is arrested. So the Miranda warning is part of the Fifth Amendment, and it does include your right against self-incrimination. The Miranda warning, or the Miranda rights, was from the court case of Miranda versus Arizona in the 1960s. Ernesto Miranda was accused of rape and kidnapping, and he was interrogated by police, and he actually did confess to the crime. His trial included very little evidence apart from his confession, which the police had on some sort of recording. However, Miranda appealed his case to the Supreme Court, and the Supreme Court combined his case with 3 others. In fact, they determined that the accused must be warned of their rights, that is, their right to have an attorney and their right against self-incrimination, before interrogations can begin. An illegally obtained confession can be ignored if evidence itself can convict. So in certain cases, if a confession was illegally obtained, that confession can be ignored if there's enough evidence apart from that to convict the accused person of the crime. Please note that there is something called the public safety exception. In some rare instances, police can waive the Miranda right reading to criminals who are deemed a public safety threat. For example, if someone is arrested and accused of setting up some kind of terrorist attack that has yet to be taken place, the Miranda rights can be waived because that is a threat, a serious threat to public safety. The Sixth Amendment is another portion of the rights of the accused under the Bill of Rights. The Sixth Amendment is piggybacking on the Fifth Amendment and includes the criminal court proceedings. You have a right to a fair and public trial, you have a right to an attorney, and a right to call in witnesses on your behalf. The Sixth Amendment stems, one of the landmark cases stems from this case called Gideon versus Wainwright. This case took place in 1962, where a man in Florida was accused of a very serious crime, and he stood trial without an attorney. The state had usually given attorneys to those who could not afford one in felony cases only. However, the Supreme Court determined that counsel or an attorney, which is what it means, must be appointed for you if you cannot afford one, because the Founding Fathers agreed that the rights of the accused, regardless of their circumstances, should be upheld. It also held that habeas corpus and arraignment are required. Habeas corpus is the right to know what you're being accused of, and arraignment is the hearing which the public will officially be notified of what you are also being accused of. The final right of the accused under the Bill of Rights is the Eighth Amendment. The Eighth Amendment protects citizens against cruel and unusual punishment, as it is prohibited under the Constitution. The Eighth Amendment has typically been tried throughout the course of history, but most recently and most pertinently, in 1972, there was a case called Furman versus Georgia that argued whether or not the death penalty is constitutional. There were many components of this case, but overall, the death penalty is not considered cruel and unusual punishment if it is applied to cases where murder has been committed. So in those cases where there has been serious rape or torture, generally the death penalty has been discouraged from being used. Most states have what's called a bifurcated trial process in order to determine the capital punishment, which is the death penalty, which means that one case tries whether or not the person is guilty of that crime. So one trial determines that, and then there's a second trial, that determines whether or not capital punishment, the death penalty, can be applied. Most recently, within the last 10 years, the Supreme Court has determined that the death penalty cannot be used in cases of juvenile crimes, where the accused or the guilty, either one, cannot be put to death as the brain development has not fully centered during that time of their life. So these four amendments make up the basis of what is the rights of the accused under the Bill of Rights, which is the first 10 amendments to the United States Constitution. There has been much controversy surrounding these four amendments, and the Supreme Court continues to argue and hear cases about the subtleties of the language that the Founding Fathers included in our Constitution.